Okay, now let's turn to equal protection of the laws. The Equal Protection Clause of the 14th Amendment says that no state shall deny to any person the equal protection of the laws. Now, who exactly is protected? Well, all persons, including corporations and non-citizens, are protected. And against whom is the clause applied? Well, because it appears in the 14th Amendment, it protects against state and local denials of equal protection. But in terms of the federal government, although there's no specific equal protection clause applicable to the federal government in the Bill of Rights, the Equal Protection Clause has been read into the Due Process Clause of the Fifth Amendment in the Bill of Rights. And I've even seen some reference to this by judges as being a form of reverse absorption. Just like the Due Process Clause of the 14th incorporates the Bill of Rights against the states, so the Due Process of the 5th, by reverse absorption, incorporates the Equal Protection Clause against the federal government. But however you describe this, it means that, technically speaking, if the federal government, let's say, is denying equal protection by racial discrimination, you would argue that the federal government is violating the equal protection component of the Due Process Clause of the Fifth Amendment. All right. What do we mean by equal protection? What is this a guarantee of? Well, we know that all laws can't apply equally to everybody all the time. In fact, if we had such a rule, such a general equality rule, there would be no legislation, because inevitably legislation has to treat people differently, to classify them on some basis. For example, if the legislature decides that people can't drive cars until they're a certain age, that's a classification, a discrimination. Some who are of a certain age can drive, and those who are not of a certain age cannot drive. And in general, when the government does this sort of thing, treating people differently and making those kinds of distinctions in the law, we don't worry too much about violations of equal protection. We assume that that's part of the process of legislation. What then does equal protection protect? Well, first, it protects us against arbitrariness. And so if the government draws classifications, you can drive at one age but not at another, you can go into certain businesses for so many hours, but you can't carry on that business after noon or after midnight, any kinds of classifications like that. With respect to those, there has to be at least some basis. The law and the distinction that it draws cannot be completely arbitrary and crazy. But that's a very, very lenient test, and it's akin to the rational basis test we've already seen under substantive due process. And pretty much, as you'll see, to invoke that rational basis test is to basically uphold the law and uphold the distinctions that the legislature has drawn. And in general, we can say, when the government treats people differently, based upon ordinary economic, social, and general welfare criteria, it will be judged under this lenient rational basis test and upheld. However, in addition to protecting us against arbitrariness, which is obviously a very, very tiny, itsy-bitsy kind of a protection, the court has identified 5 bases of different treatment that will be judged more severely under either what we call strict scrutiny or intermediate or mid-level scrutiny. Now, these 5 classifications are discrimination on the basis of race or ethnic origin, discrimination based upon alienage, not being a citizen, discrimination based on gender, discrimination based upon illegitimacy, by which I mean a person whose parents weren't married when they were born, and finally, discrimination based on the exercise of a fundamental right. Now, when you have these 5 bases of classification used by the government, these 5 bases of treating people differently, the rational basis doesn't apply, and instead we apply something far more rigorous. Now, before we get to looking particularly at those bases of classification, we have already learned one thing, which I want to discuss now. Obviously, it's going to matter very much for equal protection purposes. What basis does a law classify? On what basis does a law classify? So, in equal protection, we have to first ask frequently, how do we know on what basis a law is actually classifying? Is it classifying based upon income? Is it classifying based upon age? Is it classifying based upon race? Because as I said, given the structure of equal protection doctrine, if the government is classifying on one of the 5 bases that I've mentioned, you're going to have a very rigorous test applied, but everything else will be judged by rational basis review. So in the first place, you have to figure out the basis on which a law is classifying. Well, how do you start? Well, of course, you begin by looking at the law on its face. And sometimes you can answer the question right from there. You can determine, for example, whether a law is classifying on general economic or social bases, or whether it's classifying on one of the 5 bases that will trigger a heightened form of review. For example, if a law on its face said that men, but not women, could serve as administrators of estates, then clearly that would be a classification based upon gender, and the rules governing gender discrimination would apply. And that's a pretty easy kind of case. You just look at what the law actually says. But what if a law is neutral on its face? It doesn't mention any of the 5 bases that will trigger heightened review. It looks like an ordinary economic and social piece of legislation. How then do you determine on what basis it classifies? Do you simply look at the face of it? Or might you look somewhere else in addition? Well, you might look to see whether the law, although neutral on its face, is actually applied administratively with the bad purpose to discriminate on the basis of race, alienage, gender, etc. And if you discover that that's the case, then you will judge it as a discrimination on that basis. Take an example. There was a case, Yick Wo versus Hopkins, and Yick Wo and Wo Lee sued to challenge a San Francisco ordinance that said if you were going to operate a laundry in San Francisco, you had to operate it in a stone or cement building. And the reason why San Francisco had that rule, of course, is that it was worried about fires. So they said you had to operate laundries in cement buildings. Fine. Now that law looks neutral on its face. It looks like it's an ordinary economic or social classification. If you're operating laundries, people who are in that kind of business have to have stone buildings. It doesn't talk about race or gender or illegitimacy, alienage, anything else. However, as it turns out, in application, what was happening was that every Chinese American who came in to get an exemption from the law, because the law provided that exemptions could be given, every Chinese American who came in to get an exemption was denied. But every non-Chinese American, every white person who came in and sought an exemption, did get it. And what the plaintiff said in that case was even though the law was neutral on its face, it was applied administratively with a purpose to discriminate on one of these 5 bases. In this case, race or ethnicity, and it should be judged on that basis, and the court agreed. More recently, the court has looked at cases where legislatures have drawn legislative districts, and the court has said if the predominant purpose behind how the government is drawing those districts is race, then that's going to be judged as a form of racial discrimination. So that's a kind of a case where you look for facts showing discriminatory application or a discriminatory purpose lying beneath the surface in the evidence by how the law was applied. And that's a little trickier, but you can manage it. But now we get into our really hard case. What if a law is neutrally written and it's neutrally applied? But what if it has a disproportionate effect, let's say on a racial or gender basis? Should we judge such a law as a racially discriminatory or gender discriminatory law? Well, the issue came up in a case called Washington versus Davis. In that case, the city of Washington, D.C. was using a general intelligence test as a screening device for people who wanted to be police officers in Washington. Now, as it happened, for whatever reason, whether because the schools were bad or discrimination existed in the larger society, we don't know. But for whatever reason, it was turning out that many more blacks than whites were failing the test. And so a group of black applicants brought suit, saying that this is a form of racial discrimination, and it should be struck down applying the rules that apply to racial discrimination. It shouldn't be judged by applying the rules that